Economic Offences, which was the predecessor of what we now call the Scorpions, says that it is doing its own investigation independently into the arms deals. And funnily enough, at the same time, Mr. Zuma starts building in Kandla with a budget of 1 million rand, but that's by the by. Let's just stick to the question about the Scorpions' predecessors getting involved. Were you ever made aware of the fact that there was a police investigation into the arms deals?
No, I don't remember that.
Now, it's documented in the Shabir Sheikh trial that Jacob Zuma, Alan Tettard, Shabir Sheikh met in Durban on the 10th and 11th of March of 2000. And the court accepted that the purpose of the meeting was to discuss a payment of a 500,000 euro bribe to Mr. Zuma in return for protection against investigation into Thompson's potential corrupt activity in the arms deals. In other words, they were getting nervous about what all the noise that was going on about irregularity. That was all over the press. Do you remember that, or was it just something that it didn't involve you?
Sure, I remember it, but I mean, it didn't involve us.
I do need to ask you this question, given that kind of publicity, because you are a senior statesman in Africa today, and you are working to make Africa a better place. I'd like your view, if you would share it with us, please, on the propriety of a person in the position of President Zuma appointing sitting judges to preside at a commission of inquiry of this nature about subject matter such as this. And I see Mr. Marani is already upset with me.
Just so, Mr. Marani, before you say anything, I'm not going to allow the question. It's not necessary for the former president to answer the question.
I accept that, Mr. Commissioner. It's perhaps something for another day in another forum. Now, on the 15th of August in the year 2000, the first Auditor General came out. That's the first official report of the Auditor General's investigation. And in it, he raised some serious questions about the rectitude of the acquisition process and recommended that there be further investigation, which I think led to JIT eventually. Does that accord with your recollection of the chronology? Is that the way things happened?
And that's possible, I don't know.
Do you also recall that Selby Bakwa, who at the time was the public protector, announced almost simultaneously that the Public Protector's Office, which is there to guard against maladministration, said it too was going to get take an interest in what happened in the arms deals?
Yes, I can't remember all of this detail about things that happened then, but I have no doubt that this might very well have happened.
And then on the 9th of October, which was quite soon later, was quite soon after that, the Heath unit lodged a request with you to be granted a presidential proclamation, because the SIU works in terms of presidential proclamations, giving it the right to investigate the arms deal. So we've got Patricia de Lille, the Heath unit, the Auditor General, and now in October, the Public Protector in August, all swarming all over the arms deal. Is that the way that your presidency began?
The Special Investigation Unit, or the Heath Unit, doesn't present a request to president unless the law has been changed since we left government. they would have presented that request to the Minister of Justice, not to the President. On the recommendation of the Minister of Justice.
Then I want to go to the first Scopa hearing, which I know you weren't involved in because you were in the executive at that stage. But what emerged there was that by October 2000, the cost of the deal had spiraled to 43.8 billion, and that there wasn't proper provision in the agreement about what happens if the offset deals don't really materialize. Do you remember any of that, Mr. Mbeki?
No, I don't.
Do you remember that Chippy Sheikh, when that was all happening, suggested that he recused himself from discussions in which he would be in a conflict of interest, but that was found to be false when the JIT got involved in the investigation?
Well, I mean, I only recall that, Chairperson, in the context of the report of the JIT, that the JIT did discuss that particular matter. I don't know what earlier discussion took place about it.
And I don't think we need to go into what Shabir Sheikh's fate was. There is a court record, and we all know that he was given 15 years for corrupting Jacob Zuma. Let's just accept that as part of the narrative, and that is in fact what followed. You happy with that?
Yeah, sure.
Okay. Now we get to the month of October 2000, and we have Scopa releasing its 14th report, which is the one we call the JIT report into the arms deal. And that report urges your government to form a super investigating team to investigate the arms deal, and it argues that the SIU should be involved in the process because the SIU has these powers to cancel deals that are unconstitutional or illegal or induced by fraud or whatever it is. Do you remember that, Mr. Mbeki?
Yes, no, I remember the recommendation of the Scopa, more or less in the terms that you are stating.
And then from another quarter altogether, in December of 2000, the Speaker of Parliament, who was then Freni Jinwala, came into the row that was going on in Scopa between Woods and Feinstein on the one side and the ANC members on the other side. You remember that? And she says she was not, and I'm putting this in quotes again for Mr. Marani's benefit, not aware of any resolution of Parliament, of the National Assembly, instructing the President to issue any proclamation regarding the work of the Heath Commission. Well, I think you've answered that already. You say that's something that the Minister of Justice should have done, not Parliament.
No, Chairperson, she was not addressing that issue. What she was addressing was she was saying that a parliamentary committee has no authority to direct the executive to do anything unless that is done by resolution of... that's the matter she was addressing.
Well, we can agree on that one. Then we go to January of the next year, which on the 12th of January that year, Ministers Irwin, Manuel, Khadebi, and Lekota had a press conference at Johannesburg International, which is now ORT. And well, I'd like to know if they were there. Obviously, they were collectively responsible with you for what happened. Were they there with your blessing or your knowledge, or did they just do it on their own?
No, it agreed that they should do that.
And what they did there was to defend the procurement process while noting that the cost had gone up because of inflation and that the procurement didn't really deal with the secondary contracts. You left that to the contractors to do rather than make the secondary contracts government contracts. Is that really the line that was taken when they stood up at ORT and held their press conference?
I'm sure that's what the statement said. That was the position of government anyway.
Then, a couple of days later, on the 19th of January, you wrote a letter to Judge Willem Heath, and you said to him, you're not going to give him the right to investigate the arms deal. Do you remember that?
We communicated to Judge Heath on the basis of a recommendation by the Minister of Justice, which said we had an obligation to implement a decision of the Constitutional Court, which said that that particular unit, the Special Investigation Unit, the Heath Unit, was improperly constituted, and therefore that we needed to change it. And indeed, therefore, the Minister of Justice said, on the basis of this, we have to do this, and that certainly was part of the argument.
It was a separation of powers issue. You had a member of the judiciary working in the executive, which is not a healthy thing when there's a separation of powers. Is that really what it was?
Well, I'm not a lawyer, but I'm just saying what I could recall is that the Constitutional Court said it was improper for us to appoint a judge to head this commission. We needed to find somebody else. But that I know. Quite what the detailed argument would have been at the Constitutional Court, I don't know. I can ask the lawyers who are around me here, including you.
Please don't, otherwise we'll never finish. I'm indebted to Mr. Marani for drinking instead of talking. It's very much easier to get on with the show. The quote, and this is once again inside quotes for counsel's benefit, of what you said there worries me, and I want to talk to you about it. Because the quote of what you said in relation to that is, it is clear that we cannot allow the situation to continue where an organ appointed by and accountable to the executive refuses to accept the authority of the executive. This situation of ungovernability will not be allowed to continue. Now that's, with respect, Mr. Mbeki, is a general statement which I don't think you really meant to say. You were dealing with it specifically in the context of a separation of powers hiccup. If you took what you said there literally, it would actually chop off at the knees everything that every Chapter 9 institution does. And I don't think that's what you meant, and I would be much relieved to hear that you agree with me that's not what you meant when you said it.
The Heath Unit, so-called, is not a Chapter 9 institution. I'm quite sure the comments that I would have made to the unit relate to what certainly the government thought the unit was doing. So it's got nothing to do with Chapter 9 institutions. It's got to do with particular behavior at a particular time by a particular unit.
Yes, now I'm very pleased with that answer, and I thank you for it, because it is a source of concern where the separation of powers is so critical to the success of constitutional democracy in a multi-party setup like ours. So let's move on to what happened in January of, later in January of the same year, when the ANC members of Scopa put out a press statement saying that Scopa had never directly asked for Heath to be part of the investigation team, and they made Andrew Feinstein read that out in Parliament. Do you remember that incident?
No, I'm afraid no, I was not in Parliament.
Okay. Do you know that after he said it, he actually retracted it? He retracted the statement when he saw the reaction.
As I've said, Chairperson, I was not in Parliament. I don't know what these parliamentarians were doing. I don't know what these parliamentarians were doing.
I want to move all the way to May because I'm mindful of the hour and we are making wonderful progress. So let's go to May of 2000, where once again this joint parliamentary standing committee on ethics and members' interests forced through a resolution that was to the effect that Tony Yengeni, who was in trouble with his Mercedes-Benzes, did not have to appear before the committee to answer questions relating to the claims that those were involved in the arms deals. Did you have any role in that, or did that just happen at parliamentary level without any input from you?
Chair, I think we're wasting time. These were parliamentary matters. Mr. Becky was not involved in those parliamentary matters. Can we please get on with it?
You know, my co-commissioner here was just pulling me saying that are we still within our mandate? These questions that are being asked are relevant to our mandate. And I said to him, no. I'm not quite sure which term of reference this information that Mr. Hoffman is trying to elicit from Mr. Mbek is going to Mr. Hoffman, is
yes,
that...
Let me put it succinctly. Part of your mandate relates to the cover-up, does it not? Well, this is where I'm at.
Which paragraph will that be?
It's the question of how institutionally the allegations of wrongdoing, misfeasance and malfeasance in the arms deals were dealt with subsequent to the deals being done. That's all. I'm not trying to make a big song and dance. I'm trying to get through.
No, that I understand. I've got the terms of reference. Which one? Can you just refer me to the relevant portion? Maybe I'm the one who misunderstood them.
It's 1.5, yeah. My instructions are it's 1.5, and I'll check my instructions because my client has been reading these things longer than me.
Can we just read that into the record? Maybe, you know, our understanding is not the same.
Yes. So it's 1.5 of your mandate. You want me to read it out?
And that's right, because that doesn't seem to be our understanding of 1.5.
It's a question of how you interpret the words, not award, which is what goes before, but conclusion of the contracts awarded and concluded in the SDPP procurement process, and if so, whether legal proceedings should be instituted against such persons and the nature of such legal proceedings, and whether in particular there's basis to pursue such persons for the recovery of any losses that the state may have suffered as a result of their conduct. Now, if there is conduct that is designed to cover up wrongdoing in abstracto, let's not talk about this here, then there is a basis for saying that mandate is part of or that wording is part of your mandate.
Okay, I hear what you're saying. You can continue. Fortunately, I see you're almost towards the end of that book. I think you are left with about 2 pages or so. Yeah, okay.
Unfortunately, the book is only chapter 1 of the list, but I don't have a lot more to do. Sorry, Mr. Mbeki. We're getting there. Is it also correct that on the 30th of August in 2000, Andrew Feinstein resigned from the ANC after being taken to task for the position that he took on the arms deals? He was a member of Scopa and he had a lot of conflict around it.
Well, I know that he resigned. When he did, I can't remember.
I'm helping you with the date. It's documented. Then I want to take you to October of that same year, where there were reports in the investigative press that Mr. Fauci, the Auditor General, had forwarded his original Auditor General's report, which was released in August 2000, to your cabinet for review, and that paragraphs implicating Chippy Sheikh in improper activities had been edited out by your cabinet to clear Chippy Sheikh. And the book by the man sitting behind me has a lot of pages in it that show that there's been editing in handwriting, and I don't want to spend a lot of time on it. I want to know whether you had anything to do with that, or whether we should be looking for other culprits in relation to the editing of the Auditor General's report in October 2000.
Chairperson, the Cabinet never edited any auditor's report of any kind. What normally happened, I do not know if the practice remains, what normally happened with regard to the Auditor General was that whichever institution, department, he would prepare the audit report, he would show it to the people or organization, institution that was being audited, to allow them to make comments in terms of what would be before him, which reject, it didn't matter. After which, then he finalizes his report. That's normal. That's normally what he did. And in this case, in the case I'm talking now, but in the case when there was a JIT and he had to prepare that report, he followed the same normal procedure. There was nothing extraordinary about it. And there was nothing that would have been edited out by members of the ministerial committee. It was not cabinet. But no doubt there would have been comments if we thought that there were some things that the Auditor General had got wrong. As I say, with no obligation on the Auditor General to accept whatever we said. But that's normal practice with the Auditor General. They didn't do anything which was extraordinary with regard to this particular matter.
So what you're saying is that the procedure really mirrors the procedure that the Public Protector now does with her confidential provisional report, which is then given to interested parties to comment on, goes back to her, and she then makes her final report. It's not a question of somebody saying this has to be in the final report. It's a question of input being given. That's if I summed you up correctly.
Well, Chairperson, I don't know what the Public Protector does. I was talking about what I know about the manner in which the Auditor General conducted his work while I was in government with regard to any audit report. That they would prepare the report, show it to the person, institution who was being audited, get whatever comments, and then finalize the report. And they followed exactly the same procedure in our case.
Do you remember that Shabir Sheikh was arrested on the 16th of November that year and charged in relation to his relationship with Mr. Zuma? and that on the same, well, I think you do remember that, but that on the same day you wrote an article in ANC Today attacking the joint investigation report.
I don't recall attacking the joint investigation report, Chairperson. I might have made some critical comments about elements of what they said. As I say, I can't remember attacking it because, of course, we can always find that letter. It's on the internet. It's not difficult.
Yeah. Can we prevail upon Mr. Marani not only to make that ANC Today editorial that you wrote on the 16th of November, but also sometime later, I'll pick up the date, it's the 30th of May. I think those were the only two that I know of that you wrote in relation to the arms deal. Can we ask to prevail upon him to make them available to the Commission and to the parties represented?
Chairperson, I decline the invitation. Mr. Learned colleague Hoffman and his client can do their own work.
Are you going to pay us? On the 25th of February 2002, the chairman of Scopa, Gavin Woods, resigned from Scopa in protest. Your government handled the arms deal investigation. Do you recall that event, Mr. Mbeki?
Yeah, I do recall that Mr. Gavin Woods left Scopa. Quite why, I don't know. I'm sure that this is a matter that would have been discussed in Parliament.
And it left you cold, neither here nor there. You had no reaction to it at all.
Mr. Hoffman, can we continue the cross-examination? He says he doesn't know. Okay. Let's go and get to the next question.
I'll move on, thank you. Now, by the 13th of March 2003, there had been litigation involving Richard Young, who was one of the disappointed tenderers in relation to the IT for the corvettes. And I'm instructed that on that date, the 13th of March, the Auditor General dropped his appeal against a judgment in favour of Richard Young, meaning that the Auditor General had to release documents requested by Young, including the draft JIT report, which is all over Henny van Vieren's book now. And the extracts show that the report had been heavily edited in order to reflect more favourably on the government. Are you in a position to dispute any of that, or do you simply take it as a statement of what went on that you are unable to contest?
Chairperson, it's not very pleasant to be objecting at every turn, but I really, really do not see the relevance of this line of questioning, particularly in the light of the evidence of President Mbeki.
Let me help Mr. Marani. On the next occasion that anything of relevance to this matter occurred, Mr. Mbeki wrote a column in ANC Today where of what had happened there. So he made a comment at the time. And that's why it's relevant, because he obviously regarded it as something of importance. But we will do our homework. We will go and scratch in the internet. We will find the articles that were written, and we will produce them when Mr. Crawford Brown gives his evidence in due course. So let's not...
I think I agree with you.
Let's do it
Do
then.
your homework, get those articles, give them to Mr. Crawford Brown, and then he can produce them when he gives evidence.
Thank
I
you,
think
Mr.
maybe
Commissioner.
there's a much better way of dealing with
Thank you, Mr. Commissioner. Moving on then to June, that is when Patricia Hewitt, who was then the British Trade Minister, Under Secretary for Trade in the UK House of Commons, stood up and said that BAE had paid commissions to agents to help secure the Hawke Gripen deal, and that the amount involved was £112 million sterling. Did you take note of that announcement in any shape or form?
I'm not going to allow the question whether, I'm sure you will not know what the British have done or what announcements they've made. Whatever answer is going to give us, I'm not sure. Get to the next question.
Okay, the next question is there any provision in any of the arms deals for the payment of commission to intermediaries? Because I haven't been able to find one myself, and if you found one for me, I'll be deeply indebted to you, Mr. Mbeki.
A payment by whom, Chairperson?
Payments to intermediaries by the arms deal. The important part of this. If these deals are cancelled because of this kind of activity, the loss that accrues in respect of the bribes falls on the European who corrupted the South African officials, personnel, people who were involved in the negotiation of the arms deals. And in this particular instance, what Patricia Hewitt actually said was, we set aside £200 million.
Mr. Hoffman, what is the question to the witness?
The question is, Mr. Mbeki, that if arms deals are cancelled, recipients of keep their bribes and the loss falls on those who paid the bribes to land the contracts. Do you know that?
Chairperson, the witness asked for clarification as to who are these people who are alleged to have paid bribes. That has not been cleared, so that he's in a position to answer the question. The so-called intermediaries. I mean, if it would make sense if it related to government and it related to the primary contracts, but if it's relating to secondary crime, then it's totally irrelevant.
Mr. Commissioner, my learned friend hasn't been listening because it's late. It's BAE that admits in Parliament that it paid £112 million of commissions, which is just English language for bribes. And you have in the Terry Crawford Brown versus the President documentation a great fat wad of paper that shows exactly who was paid and how much and where and through which companies. And if my learned friend, Mr. Marani, hasn't read that, then I suggest he doesn't waste your time by asking silly questions, but he goes and reads it because it's all there, waiting for anybody who wants to read it to read it.
Chairperson, my learned colleague should withdraw that. Asking silly questions. That's not the sort of language you must be using here.
Mr. Hoffman, Mr. Marani says that he objects to the fact that you say he's asking silly questions.
If Mr. Marani had taken the trouble, both when he represented...
Are you prepared to withdraw the statement that he's asking silly questions, or you're not prepared to withdraw it?
Let me say, question prepared.
Then I'm saying, are you prepared to...
I will withdraw the silly question because Mr. Marani is not...
You will not withdraw the silly?
No, I will. I will withdraw the silly term because Mr. Marani is not silly.
Chair, I'm not quite certain whether... I know English is not my home language. But I'm not quite certain whether I've seen anywhere where it's written that the word commission is equivalent to bribe. Can you help me with that statement?
May I suggest, with the greatest of respect, Mr. Commissioner, that you do what nobody in this commission appears to have done yet, and read the papers that were placed before the Constitutional Court in order to get this commission appointed, because they are full of information that shows that these so-called commissions were paid as bribes through red diamond trading in the British Virgin Islands to the personnel like Farnish, Longwana and Breitenbach and others. We'll give you a list of names if you want them. They are actually all there and they've been before you since the day you were appointed.
Yeah, I understand that. When your client testifies, then he can lead that evidence. But then put your proposition short and sweet to Mr. Tawambegi so that we can finish with this evidence. And then the list of people who receive bribes, then we can deal with them when your client testifies. Can you just put very brief questions to Mr. Mbeki which are understandable so that they can understand? I'm sure he will be a bit confused if you say to him that, bribes in English is the same as commission. Maybe let's just try and avoid that type of language.
Those commissions, as they were so delicately called in the House of Commons, are not recoverable from the persons to whom they were paid. If there is a cancellation of the BAE-SAB deal, which we submit there should be, then 35 billion rands flows back into the coffers of South Africa, which we could use, and the bribes fall where they fall on those who paid them. Bribe is an illegal transaction, and they cannot sue Farnish Longwane or John Breitenbach or whoever it is that received that commission in the course of negotiating the BAE deal. And the same applies to all of the other deals. And that doesn't be understood generally. And I'm very concerned to know it has crossed your radar, because it's an important thing to know, not only here, but also in the work that
Mr. Hoffman, what is the question to the witness?
The question is, does the witness understand that not in the contract that are paid are not recoverable from the person who received them as a matter of law? Do you know that that's what the law is?
I've got the great disadvantage. So I really honestly don't. As I listen to the question, it's a speech and a question. As I listened, trying to understand what was being said, and indeed I must say, Chairperson, I didn't think that the words commission and bribe were synonymous. We have absolutely no evidence. And for the last 16 years, for however long this discussion has been taking place, for all of these years, there's been absolutely nobody who's presented any evidence of any kind of bribery in terms of people who were involved in the processing, particularly the IMC, the processing of the acquisition. We've been waiting for all of these years for people to say concretely, these are the facts we have. And I haven't seen any. There may be, but I haven't seen any. I'm saying this, Chairperson, because, therefore, in that context, the matter has never arisen for us to consider what would happen to whoever might have been bribed, because the matter has not arisen. So it's a speculative thing. And in this particular case, I certainly am not familiar with whatever the law might say about this.
Mr. Mbeki, I have to enlighten you as to what is on record in the Constitutional Court matter that gave birth to this inquiry, because it seems that you have not been briefed by your legal team as to what is in it. In those documents, and they were before the court when my learned friend Mr. Marani and I went there in May 2011, and they were before the court on the 12th of September of the same year, when President Zuma decided, rather than answer the documentation, he simply conceded this commission of inquiry without ever dealing with the facts. This wad of documents here is ex parte National Director of Public Prosecutions in re an application for the issue of search warrants, and it has a founding affidavit by Johan de Ploy, who is a senior Scorpion, and it identifies and shows anybody who takes the trouble to read it who was paid bribes, how much they were paid bribes, what accounts the bribes were paid in, and where in the world. It was British Virgin Islands. BAE created a company called Red Diamond Trading.
Mr. Hoffman,
and paid
Mr. Hoffman,
bribes.
what is the question to the witness? Can you just put short questions to the witness so that the witness can understand them and answer them? A very long speech, yes, it will not help us, because I also end up, forgetting what you said at the beginning. Put very short questions to the witness and let the witness respond.
Mr. Mbeki, there is ample evidence of bribery in the BAE deal. In the submarines deal, the suppliers of the submarines have admitted that there is bribery and corruption in the South African submarine deal. And in the corvette deal, you once had a memory lapse in relation to what happened when you and Barbara Masekela were together with the contractors in Paris. I don't know whether you've recovered from that memory lapse. So those are three things I'm putting to you.
Chairperson, I'm objecting to this line of questioning because, as my learned colleague correctly says, at some stage I was involved in the applications which started in the High Court in Cape Town, where Mr. Crawford Brown had to withdraw those applications because their papers...
I'm sorry, Advocate Meran, if you don't mind. Mr. Crawford Brown.
Mr. Crawford Brown, yes. I beg your pardon if I had not mentioned the Mr. part of it. He had to withdraw those papers after a couple of months, and then instituted proceedings in the Constitutional Court. That matter in the Constitutional Court was never adjudicated. It consisted of allegations which were taken from books and from certain copies of affidavits. Those allegations were never, ever tested. And at the time when the decision was made to appoint a commission of inquiry, as my learned colleague knows, I was no longer involved in those proceedings. But they remain allegations which were untested, and that is all they are.
I can respond to that. Sorry.
These averments made in affidavits and other statements before the Constitutional Court, whether the court ever made any findings thereon to say that they are proof of what they say. That's been worrying. And from what Advocate Moerane is saying, it looks like there was never any pronouncement on those allegations. You cannot therefore come and say these are facts.
May I respond, Mr. Commissioner Musi? This is what actually happened. When Mr. Crawford Brown approached me for legal advice as to what to do about the persistent failure of the South African government to appoint a commission of inquiry into the arms deals, I advised him, unlike what Mr. Moerane has just said, I advised him to institute an action. And there was a reason why I said institute an action. The reason was...
Mr. Hoffman, if you don't mind, can we just deal with one critical issue? And that is the status of the affidavits which were lodged at the Constitutional Court.
I'm dealing with that.
My understanding, and apparently Commissioner Mochi shares the same understanding, those are still at the level of allegation. The Constitutional Court did not make any factual findings as far as those allegations are concerned.
Well,
is that correct? Is that the correct legal position on it?
Let me tell you what happened properly, because you have been told information that is not a correct reflection of what occurred. There was not an application in the High Court in Cape Town. There was an action for an order compelling President Zuma to appoint a commission of inquiry. Now, as you know, in an action, when the pleadings are closed, it is possible to call for discovery and to issue subpoenas. And the game plan was to issue subpoenas on the ANC in order to find out whether all of these wild and wonderful allegations were true or not by looking at their receipt book. That game plan was thwarted by good advocacy by Mr. Moerane, for which I must congratulate him, because he repeatedly accepted to everything we did, and eventually he drew an exception which said the High Court does not have jurisdiction in a matter like this. This is the kind of matter that is only justiciable by the Constitutional Court itself. And he thought we would go away and not be seen again because we didn't have enough money for a train ticket to Braamfontein. Well, we saved up, we went to Braamfontein, and we appeared in Braamfontein in May 2011. And at that stage, there was a fairly skeletal application, a brief application, saying, look, we've been sent here because Mr. Moerane doesn't want to fight us in Cape Town, and we would like to have the opportunity of asking this court to give us the relief that we are asking for on the basis of these untested allegations, because they are allegations that can and should and ought to be tested by an independent, impartial, and full of integrity commission. And Mr. Moerane's response to that was to take more technical points and to suggest that actually we should be back in Cape Town instead of where we were at Braamfontein. So
Mr. Hoffman, with the greatest of respect, you're not answering my question.
I am.
That history is not going to help us. We just want to determine the status of those allegations made in the Constitutional Court.
I'm getting there, but it needs to be explained properly, because if I leave you with the impression that Mr. Moerane has left you with, you will be misled, and we don't want you to be left under a false impression as to what actually happened. So there we get to May 2011. We've got our story before the court, and Mr. Moerane has got a selection of technical points and no answers to the untested factual allegations which are worrying Commissioner Musi now, as very correctly, and I take your point entirely. It is something that's worrying. So the Chief Justice says to us, Mr. Hoffman, is your client prepared to go on the papers as they stand? And we say, yes, we are, because we think that we've got enough information here to justify not proving anybody was a crook or a acceptor of bribes or a ignorer of the Constitution, but that there is a case for a commission of inquiry. And Mr. Marani turned around and said, no, I'm not prepared to do it that way. I want an opportunity to be given more facts, which we gave him, and to be given an opportunity to deal with the facts. And this you need to know. I wrote about it to Mr. Soni when he was still your evidence leader. And so what happened was the case was postponed, and we supplemented the papers. We put in all sorts of extra information, including the whole story about the BAEE bribes, the Pharaoh-style admissions that their old management were crooks. And we said, okay, let's go to court. What we got back from the presidency was requests for extension in time to deal with the matter, and eventually the last extension was 15 September 2011. And on that day,
Mr. Hoffman, I understand that.
And
whatever history
let
that
me finish. Please let me finish, Mr. Commissioner, I beg you. What happened on that day is, instead of answering the allegations and the facts and the reports and the newspaper stories and the affidavits by scorpions, what we got was, we surrender, you can have your commission of inquiry. And to this day, I am unaware of any effort on the part of anybody, whether they are researchers, evidence leaders, or commissioners in this commission, to actually sit down and work their way through those papers. And when people tell me now that they don't know anything about bribes in the matter, and there's a great wad of bribes in the papers that are in that ex parte NPA matter that I've referred you to a moment ago, I really do worry, Mr. Commissioner, because what needs to happen is that those need to be investigated. Yes, they are unanswered allegations, and there's only one reason why they are unanswered allegations, and that is because Mr. Marani, or in fairness to him, his successor in title, because he wasn't always in the matter, chose not to answer what we put up to the Constitutional Court, and the Constitutional Court refused to allow us to withdraw the matter until it was satisfied that it was proper in public interest litigation that the matter be withdrawn on the basis that the allegations in the public domain in those papers were properly before a commission of inquiry. And that is why you and your learned colleague, Mr. Musi, are sitting now, Mr. Commissioner, and trying to get to the bottom of this. But to pretend that there is nothing wrong and that this is all hearsay and nonsense is not appropriate in a commission of inquiry. You are entitled to hear hearsay allegations in a commission of inquiry. You are entitled to recommend cancellations of deals, criminal proceedings, all manner of unraveling of what is going on and what has been going on. You're in a position.
Just hold on, Mr. Hoffman. We are making a long speech, and I thought we were at the stage where we are cross-examined.
Yes.
And let me just correct one thing. It is not true that those allegations that your client made at the Constitutional Court are not being investigated. It is not true. Simply not true.
I'm delighted to hear that.
Just hold on, let me finish. And secondly, it's not true that we didn't read that your client's application in the Constitutional Court. It is simply not true. I can assure you, all my evidence leaders, they have read that. There's a first document that they've read. They are fully aware of the allegations that your client made in those affidavits. They're fully aware of all the supplementary affidavits that were signed. And some of those issues we were investigating, we're still investigating. So your allegation that, you will advise us to go and read that affidavit is incorrect, because those affidavits, we have had a look at them. And then secondly, those accounts that you're referring to, I can tell you that they are being investigated. So it is not correct for you to say the allegations made are not being investigated. We thought that we are come to the public hearing to come and hear evidence, and those with further documents which proves the allegation that will help us and give us those documentation. Today, we thought that we'll call former President Mbeki to come and give evidence, and you will cross-examine him. I never expected that you will start with such a long story and make allegations like, some of those who have not read your client's Constitutional Court application should read it. If you don't mind, can we try and go back to what we're supposed to be doing? And that is the cross-examination of former President Mbeki. Put the questions as short as possible so that he can understand the questions and be in a position to give us the appropriate answers.
Thank you, Chair. And please understand, I did not come here prepared to say what I said now. I came here to cross-examine former President Mbeki, and I've been obliged to spend a lot of my day dealing with objections from Mr. Morani that call for a proper reply. And he deserves a proper reply. He's a senior member of the profession, and he's a learned gentleman. And I can't just sit here pretending that I have no answer to what he says. So if I've wasted your time, please forgive me. Let's get on with the show. Okay, get ready with those. I want to know on the...
Just hold on.
Chairperson, may I request a 5-minute stand down?
I was just about to suggest that. So we'll take a 5-10 minutes break. Thank you.
Thank you. I'll run off.
You better run. Yes.
Good evening and welcome to yet another edition of Sports Live, the show that brings you the latest local and international news, live interviews with the who's who in sport. He's the first South African to wear a yellow jersey that was at the Tour de France this year.
It's the first time that we get a boxer who's recognized by the Ring magazine as the best fighter in the planet to visit our country.
And he's very close to world record pace.